Right, so now we're going to focus on the law. We're going to look at what to advise and a solicitor's duty of care. To kick us off, we have Stephen Tromans. Stephen is a barrister at 39 Essex Chambers. His area of specialism is environmental, energy, natural resources and planning law. He's been a member of the UK Environmental Law Association since its formation in 1986. Thank you, Steve.
Thought there was going to be a ripple of applause there. It was encouraging. Anyway, it's died out. This is the first time I've actually stood at a lectern since 2019, so my presentation skills may have become a bit blunted, I'm afraid. But anyway, the overall theme of this 20 minutes or so is to explore the current state of play of the professional duties of transactional solicitors to advise and, as far as possible, protect their clients in respect of risks which climate change may or may not present. And whilst professional negligence is, of course, an area where it's impossible to lay down any hard and fast rules, it's so case dependent, it all depends on the circumstances of a particular case, and I have to say there is no definitive case which sets out the solicitor's duties on climate change. There are, I think, a number of convergent factors which now make those duties much more of a reality, and that will be my ultimate conclusion. It was very good to be taken back to 1990 by Roger Harrabin in his opening. This isn't a talk about me, but I think my history is in a way quite relevant to the subject I'm talking about this morning. So I started out as a Cambridge academic. I qualified as a solicitor. I received my enrolment as a solicitor from Lord Denning, then the Master of the Rolls, in this very room in 1981. I then taught at Cambridge. During that period, the UK Environmental Law Association was set up, as was said, in 1986. Before that, there was no forum, really, for environmental law at all in the UK. It was very much a niche area. And then I had a period as a solicitor, first of all in Cambridge, but then in 1990, I had a fairly major career development. I moved to Simmons & Simmons, a firm in London, to set up a new environmental law department, where I remained for about 9 years doing that. And the reason I'm telling you this is that when I moved there, obviously there was a degree of, if I can put it this way, a degree of suspicion amongst the partners of Simmons & Simmons as to what's all this about. You know, what's this guy got to bring to the table, as it were? Is he any use to our practice and its development? And it was really, I must say, the conveyancers who were the most cynical and the hard-nosed of the lot, actually. I think the corporate lawyers and the finance lawyers actually got it much earlier than the conveyancers. But having said that, once you got a few really well-respected conveyancers, real estate lawyers within the firm on board, then sort of everyone else came on board as well. They could see, well, these guys, we respect these guys, we can see they're telling us there's something in it. They would listen to them in a way they perhaps wouldn't listen to me as an outsider to the real estate world. Contaminated land was the issue back then, really. Climate change didn't feature anywhere, although Margaret Thatcher's white paper, Our Common Inheritance, which I think was actually a brilliant document in 1990, Chris Patten then was the Secretary of State for the Environment, did actually contain a very far-sighted chapter on climate change. So a little bit about, before we get on to speculation about what the duties are, a little bit of basic law. So the solicitor's duties to their client are defined by the scope of the solicitor's retainer. Where do you find that? Well, it may be in the firm's term of business, or it may be in, if it's a corporate client, their external lawyer guidelines, if they have them. But having said that, one can't, it seems to me, stop at the retainer. The principle is the solicitor is only to do the job they're paid to do. You know, they're paid to do something, they do it, they don't have to do more. However, what is clear from the cases is that if risks come to the solicitor's attention whilst doing something within the scope of the retainer, then they do have to warn the client about those risks, even if those doing anything about the risks might fall outside the scope of the retainer. The leading case is a Court of Appeal decision in 2007 called Stone Heritage Development and Davis Blank Furnace. It was nothing to do at all with environmental matters or climate change. It was actually a dispute between the solicitor and the client, where the solicitor had failed to warn of a possible issue over possessory title being claimed to part of a site intended for development. But the Court of Appeal took up comments made in an earlier case called Russell, Jones and Walker, and made it clear that whilst the duties of the solicitor are defined by the retainer for the work agreed and paid for, warning about something is not extra work, as it were. So they gave the analogy, you go to see the dentist with a dodgy tooth, the dentist is being paid to sort out that dodgy tooth, but if he notices something wrong seriously with another tooth, whilst he's doing that, his duty is to tell you about it. Okay, he may not have to fix it, that's up to you, but at least he's got to tell you. And the Court of Appeal thought that was actually quite a compelling analogy. They made two other points as well. First of all, one relevant factor is the knowledge and the experience of the client. So how savvy is the client about these things? What can the solicitor assume about the client's knowledge and experience in relation to that risk? And secondly, is there a hidden pitfall which, whilst not obvious to the client, may be obvious to the solicitor? It's worth thinking about how those climate change issues might fall against those two tests or criteria. There are a number of other cases, I'm not going to go through them all, about the standards of the expected of a solicitor, the standards normally adopted by the profession, the size, nature and the sophistication of the firm. So does the firm have an environmental practice? Does it hold itself out as having expertise in environmental matters? Increasingly, of course, law firms say a lot about themselves on their websites, about what they're doing themselves on ESG and climate change and so on. So it might be, if you're a firm that does that on your website, it might be quite difficult to say you don't have that expertise, as it were, if you're then sued by a client for not informing them about those risks. Also relevant, of course, importantly, guidance provided by professional bodies, by the Solicitors Regulation Body, and by the Law Society. We're going to hear from the Law Society later, but we don't as yet have any such guidance. We do, as I'll say, have a resolution. And finally, there is the potential relevance in any test of whether there is a duty in tort as to foreseeability of the harm being suffered, and whether the imposition of a duty is, as the courts say, fair, just and reasonable. And so that may depend in future on the attitude of judges hearing these cases towards climate change. Do judges think it's fair, just and reasonable to impose such a duty on the solicitor? I can think of quite a few judges at the moment who are not terribly, I think, climate change minded, if I can put it that way, but equally I think there are growing numbers who may be more receptive to that sort of argument. The law adapts itself to new situations. The paradigm, I think, being, as I said earlier, contaminated land. When I came into this area as a solicitor, contaminated land really wasn't on the radar screen. I wrote a book about it. I was on the Law Society's Planning and Environmental Law Subcommittee, which was formed around about late 1980s, which was pressing on this. The Law Society issued its initial warning card and later its practice note. And of course, contaminated land is now within the mainstream of things that solicitors in real estate transactions should be advising on. I think there's any question that a solicitor who failed to really advise properly on those risks would be anything but negligent. Climate change risks are, of course, much less specific, if I can put it that way, than contaminated land. They're much more difficult, I think, to get sort of a handle on. Obviously, contaminated land is a very property-specific risk. If you're sitting on an old tannery or gasworks, that is a real risk which affects your property, its development, essentially its safety, and the value of it. The more generic risks of sea level rise, temperature rise, instability, I think are more difficult to pin down geographically, although I'm sure we'll be hearing something on how that science is developing. I think we've probably heard some of it already. But you know, the physical consequences I'd identified for myself in writing this paper are very much those which we already heard about from the real experts on the topic. So physical consequences of flooding, extreme weather, subsidence, future legislative requirements which may affect the use of property if you're a landlord, for example, the possible future devaluation of property or restrictions on its use or development because of those environmental factors, the costs you may have to incur in future mitigation, and of course, if your client is a business, the impacts of that on the client's business. You know, how is the client's business going to operate in an area of climate stress? Is it going to be, you know, intolerable for employees? What are going to be the factors which will affect your ability to run your business? So the client will have, of course, you know, to one degree or another, a general knowledge of those factors. Anybody who watches the news can't fail to be aware of what people are saying about climate change. They may accept it or they may not, but they can't fail to be aware that people are saying there is a risk. The solicitor, I think, is more likely to have more knowledge about the legal implications of it, and in particular, I think, very importantly, of the steps that could be taken to mitigate that risk. And I think that, you know, those steps fall into two main areas, probably. The first is what searches can be carried out, what information can be gleaned in relation to the matter. And secondly, what contractual provisions might be put in place to safeguard the client. So I'm thinking here not so much, I suppose, of your average residential property purchase. I'm thinking more of the sort of commercial property transactions where there is an ongoing relationship, perhaps a long-term lease, you know, over 30 or 40 years, or an option agreement for the development of land, which may stretch into the future for 20 or 30 years. So those, I think, are and I suspect probably the audience is mainly, I suspect, you know, commercial solicitors rather than residential conveyancers, but I think particularly for the commercial lawyer, there is a big question as to, you know, what should you be saying to the client about how the contractual terms which you're drafting or agreeing could help or not the client in relation to these matters. And I think it's also going to be, isn't it, an iterative process. So the solicitor becomes aware that there could be an issue in relation to this property sparked off by climate change in some way. Let's say it's sea level rise for the sake of argument. The client can be told by the solicitor, look, there are reports you could get which will inform you on this. There are risks if you don't have that information. Obviously, it's then up to the client. If the client says, no, I don't want to pay for that report, the solicitors discharge their duty by advising them. The client gets the report. I don't think the solicitor can simply say, oh, here's a nice report, you know, go away and read it. The solicitor plainly has to try and help the client make sense of that report, summarise it, and discuss its implications. I mean, much in the same way that a client who's advising a prospective tenant doesn't just hand over the lease and say, here you are, read that. They produce a report on the lease which sets out its terms and the various probable pitfalls. And then, of course, from that, the client may ask the solicitor, well, what can I do to mitigate this? If I'm going to proceed with the transaction, can anything be done to safeguard my position? And that, of course, is where then the client may be getting specific advice from the solicitor. Now, I mentioned the Law Society a little while ago. We're going to be hearing from the Law Society later, but as I understand it, they'll tell me if I've got this wrong, but all there is at the moment is really the climate change resolution which the Law Society passed in October last year. That doesn't say a great deal, it seems to me, about the specific duties of the solicitor, but it does say some quite important things, I think, that may have implications for those duties. So it's a resolution to support solicitors to be fully informed, to disseminate educational tools and resources, to influence legal training and education, to urge solicitors to continue to engage in continuing legal education on climate change, including providing, whether through themselves or others, that's quite important, either the solicitor themselves or through others, competent advice to clients on mitigating the effects of climate change and the potential legal risks and liabilities that may arise from action or inaction that negatively contributes to the climate crisis. So I think some of that is really not so much about the protecting the client as the solicitors behaving responsibly as citizens in their own sphere of business. But having said that, I think there are some words in there which do go towards the solicitor's duty to their client. And finally, the encouragement for solicitors to develop well-supported career paths for lawyers who want to transition into distinct disciplines related to climate change and to engage in pro bono activities that support this objective. So that's where we stand at the moment. So that in itself is plainly not going to create a duty of care, it seems to me. However, I think the important thing to note is that the standards which are expected of a solicitor are capable of being ratcheted up by improvements in knowledge and best practice within law firms. As that knowledge increases, best practice goes up, so the bar for solicitors generally is going to rise, it seems to me, inescapably. And there was a recent quite good article online from Sarah De Gay, visiting professor at UCL, on this issue, where she says the more solicitors who rise to the challenge, the more likely it is arguably that a duty to advise could be created. And that seems to me to be absolutely correct. And so I think that this is where the things like the Chancery Lane project come in. I know if I'm sure many of you are very well aware of the Chancery Lane project. It's a cooperative project between solicitors' firms whereby they cooperate on a pro bono voluntary basis to come up with and draft clauses on climate change and other environmental matters, which then solicitors are free to use. I think it's sort of open source, anybody can use them. But all of that learning, all of that information is out there now, so are solicitors obliged to keep themselves up on that? I think, yes, they are. And also, as more tools, we'll hear about the tools that are available, the searches and so on, but as more tools and information to assess climate risks become available, so it seems to me solicitors must be expected to make themselves aware of what's available and to discuss with clients the importance of the investigation, though obviously, as I said, the final decision is for the client. However, the decision should be for the client, I emphasise, properly advised by the solicitor. So I think the solicitor must make clear to the client the implications of not going ahead with a search which is available. So that's taken me, I think, to my last point. Coming back to this lady, the visiting professor, Sarah De Gay, she says, on the question, do solicitors in England and Wales have a legal duty to advise their clients on climate-related risks? The initial answer is most likely yes, and I think I would agree with that. So that's really it. I'm going to hand over, I think Stephen Sykes is up next, I think following on quite logically from what I've dealt with. Thank you.